This is really a full and festive evening, considering that there is so much talent and knowledge here. Each one of the people that you see up here could speak for hours, and indeed they have in different settings before the Congress, on the media, and in books and so forth. So we have a packed evening, and it didn't happen by accident. When you get people of this talent together, because we shopped around to get a world-class panel, considering that stolen art is a subject that draws on many, many disciplines, not only art, of course, but politics, international treaties, congressional statutes, economics, investigative skills, and all that goes with it. And along with provenance and the like, it's often that one finds oneself in litigation over matters of this kind, and that's why we are the Historical Society of the Courts and presented this program. So I want to thank Marilyn Marcus and Dan Sierra and Allison Maury for helping us put all of this together. We thought that we have lawyers here and His Honor on this side, and the speakers, presenters on the other side, although you're going to hear from each of the people up here on this side of the podium. And we'll begin. I'm Al Rosenblatt of the Historical Society, and we're going to begin the evening with Dr. Sharon Flescher. She's the Executive Director and CEO of the International Foundation for Art Research, and she's Editor-in-Chief of its quarterly journal. She's a Barnard graduate with a Master's in English, Literature, and Art History with a PhD from Columbia University. She also attended the Wharton School at Penn. She's been a director of the Equitable Foundation, a program officer of the National Endowment for the Humanities, and has held positions at the Central Park Conservancy, the Metropolitan Museum of Art, and Brooklyn College, and CUNY. She wrote a book on Zachary Astruc. It was published in the Outstanding Dissertations in the Fine Arts series. Her numerous media appearances, you may recognize her if you see her here from her appearances on the BBC, NPR, WCBS, ABC, Nightline, and NBC Today. And she will begin the program by giving an introduction and an overview on stolen art restitution. We'll then be hearing from Monica Dugot, an attorney, who was Senior Vice President and International Director of Restitution at Christie's, because we wanted to have not only someone to give the introduction, but someone from the auction art world from that viewpoint. And she coordinates restitution issues globally. And before joining Christie's in 2004, she served for 8 years as Deputy Director of the New York State Banking Department's Holocaust Claims Processing Office. She represented New York in art restitution matters at many venues, including the 1998 Washington Forum on Holocaust-era assets and International Conference on Holocaust-era looted cultural assets in Vilnius, Lithuania. More recently, she testified before the United States Congress on restitution issues, and she delivered a TEDx talk. Thank you, Monica. We're also going to be hearing from Ray Dowd, now the lawyers. And these are people who we looked for in order to bring a world-class panel of attorneys before you. Ray Dowd is a partner at Dunnington Bartholow Miller, and his practice includes foreign law and conflicts of law principles, discovery in foreign jurisdiction, and litigation to recover works of art lost during World War II. He regularly represents television broadcasters in disputes relating to brand protection and content distribution in the United States, particularly anti-piracy work. He earned his BA from Manhattan College in International Studies, cum laude, and a JD from Fordham Law School, where he served as articles editor at the Fordham International Law Journal. And some of you may be familiar with his book, published by West, entitled Copyright and Litigation. And he's going to speak on the law and the history of Nazi art looting. Larry Kaye is a partner of Herrick Feinstein and he's noted for representing foreign governments, victims of Holocaust, families of renowned artists, and other claimants in the recovery of art and antiquities. He was the lead attorney in a landmark case called Federal Republic of Germany versus Elikofan, in which two early Albrecht Dürer masterpieces were stolen at the end of World War II and were recovered and returned, thank you, to the Weimar Art Institute. He also represented the Republic of Turkey in recovering the fabled Lydian hoard antiquities and some 1,800 ancient Greek and Lycian coins, which Connoisseur magazine called the hoard of the century. Larry successfully represented the heirs of the Russian artist Kazimir Malevich in their claims against the Museum of Modern Art, Harvard's Busch Reisinger Museum, and the Stedelijk Museum in Amsterdam. We'll next hear from William Pearlstein, an attorney and founding member of Pearlstein McCullough Lederman in New York. His art practice is the outgrowth of his experience as a New York transactional lawyer with broad experience in corporate and commercial law, including securities, private equity, mergers, and acquisitions. He graduated from Yale in English. His degree is in English, and from Northwestern Law School, where he served as notes and comment editor of the Journal of International Law and Business. He then joined Chadbourne and then Milgram Tomajan, and later served as counsel for Golenbach, Eisman, Asser, and Bell before founding Pearlstein McCullough Lederman. And he's going to tell us, through his experience, about what he has characterized as what we all would recognize to be the tension between congressional and judicial policy governing antiquities trade. And the Honorable John Walker, you all know him, and many of you have been before one of the most distinguished courts in the United States, if not the world, and he is a premier American jurist. He's the senior circuit judge and formerly chief judge of the Second Circuit Court of Appeals. You'll find him in Foley Square when he's not in New Haven. Before that, he was a federal district judge. Before that, an assistant United States attorney. And as you might imagine, from that position, he was elected president of the Federal Judges Association and a member of the Judicial Conference, which is really the governing body of the federal courts. He's a lecturer at Yale, where he's often found. He's also a director of the United States Association of Constitutional Law, the International Judicial Academy, and he's on the board of the CEELI Institute in Prague. He has his BA from Yale and JD from Michigan Law School. He was in private practice at Carter Ledyard, and then became Assistant Secretary of the Treasury. I saw that on your resume. I didn't know you were Assistant Secretary of the Treasury. Well, there it is, in 1980. What?
I was just an assistant.
Okay. Well, we could use you now. He has worked with judiciaries to further the rule of law in China, the Middle East, and Central and Eastern Europe, and is the recipient of the Learned Hand Medal for Excellence in Federal Jurisdiction and many other awards. And he's going to be the moderator, and we need someone like Judge Walker to be the moderator because this is going to be a very lively and festive give and take after each of the speakers has what we have allocated as about 11 minutes. This is not easy because there's so much here, and what you're watching here before you is the result of how many conference calls? Bill, how many conference calls would you say? At least what, 4 conference calls to sort things out. So you're now about to get the final product, and Dr. Sharon Flescher, can you start us off? Thank you. Sharon, come on up.
Thank you very, very much. As the start-off speaker tonight and the non-lawyer of this panel, I want to thank the Historical Society and the Bar Association for inviting me to participate, and thank you all for coming, frankly. My task, which is to provide an introduction to an overview of art looting and restitution issues in just a few minutes, is clearly not doable, frankly. So I've called my talk an introduction and overview from A to B, because I'll only be able to touch the surface, and will probably raise more questions than I'm going to answer. Wartime looting isn't new, of course. It goes back thousands of years. Think ancient Rome and Napoleon. To the victor always went the spoils. But the magnitude of Nazi art looting, both before and during World War II, eclipsed anything known before or since. The enormity of the looting is magnified by its connection to Nazi ideology of racial purification and genocide. So it's not just looting, really. Both Hitler and his right-hand man, Hermann Goering, were avid art collectors of the confiscated art. Here's Goering looking at 2 looted Matisses. No one knows the exact number of works that were looted during the war, and everyone counts these works differently. But if books, Judaica, individual prints and drawings from portfolios, etc., are included, the looted objects certainly number in the millions. I don't have time to give a full history of this, but it's important to say a few words about why we're in the predicament we are almost 75 years after the end of World War II, still dealing with Nazi-era art restitution claims and the Provenance Research and legal wrangling that it entails. Even before the start of World War II and as early as the mid-1930s, Jews in Germany had to register their artworks. Nazi laws in Germany made it difficult for some Jews to practice their profession or carry on businesses. The art confiscations themselves didn't start in Germany until around 1938 and later in the occupied countries. Some people who were prescient and were able to got themselves and their artworks out of the country in time. Others sold their works just to have liquid cash. Still others were forced to sell in exchange for exit permits or to pay the flight tax or other reasons, possibly with a literal or figurative gun at their head. Some were affected by the generally bad climate, economic climate. Let's not forget there was a worldwide depression in the 1930s affecting everyone. That said, there was also a thriving legitimate art market in Europe, especially in France and the US, before and even during the war. And sometimes it's difficult, 75 years after the fact, to say whether a particular sale was a voluntary one or one that was forced at then well below market values. Then market value, not today's crazy art prices. Understanding, however, that market value fluctuates all the time, even now. Although a declaration in London in 1943 during the war governed presumptions about sales in Nazi-occupying lands, saying that they should be presumed to have been forced unless otherwise shown. In actual fact today, defining and dealing with so-called forced sales, or much more problematically, sales said to have been made under duress, including sales made when the seller and artwork were already out of Germany or the occupied lands and not under immediate Nazi threat, remains, in my opinion, one of the thornier aspects of art restitution, about which honorable people often disagree, and I would venture to say that on this very panel, people would disagree. If I had the time, I could discuss in depth several paintings, including these works by Gauguin, Picasso, and Van Gogh, where the claimants' assertions that the works had been sold under duress were strongly contested by the museums and individuals who later acquired them based on their own provenance research. The Toledo Museum, MoMA, and the actress Elizabeth Taylor. In a few of these cases, the museums and also Ms. Taylor filed declaratory judgment actions to quiet title because they believed the cases had no legal or factual merit, and they wanted to avoid the expense and uncertainty of litigation, angering many people in the claimant community to this day who object to the fact that the museums were both judge and jury. Summaries of these particular cases and dozens of other Nazi-era restitution claims can be found on IFAR's Art Law and Cultural Property database. It's online. And since there'll be a talk tonight from Bill Pearlstein about antiquities issues and foreign patrimony claims, I should mention that the database also has sections devoted to what might be called the mushrooming and difficult to find body of foreign patrimony laws and also case law governing the ownership and export of art and other cultural property. Currently, the database has legislation from 123 countries, and we're about to add 2 more. Unfortunately, I don't have the time to go into these issues tonight, other than to say that the foreign ownership laws are predicates to the legal actions in the United States. So now let's get back to World War II. Where did the looted art go? Some of it was hidden in salt mines in Germany and Austria, such as Alto See in Salzburg, near Salzburg. In France, a Nazi unit, the ERR, was put in charge of acquiring, in quotes, cataloging and storing artworks, mainly from French and Belgian collections. The ERR was meticulous in documenting their actions, which has proven invaluable for restitution purposes. And here I'm just showing you one of their cards that have now been digitized, incredible resource, together with the painting of Pissarro about which the card refers. It happens to have been from an unknown owner at the time. After initially storing the works in the Jeu de Paume in Paris, the best of the items was sent to the Disney-like castle of Neuschwanstein in Bavaria. So many artworks were stored here, and the castle was so deep that after the war it took 6 weeks to empty it. And after the war, the Allies did a Herculean job of returning hundreds of thousands of works. Not all works were restituted, however, and they did make some mistakes. The now famous portrait of Wally, for example, the focus of an ultimately successful but drawn-out restitution claim, was initially returned to the wrong family after the war. You've all heard about the so-called monuments men who helped protect European monuments during the war and then retrieved, sort, and returned the stolen objects afterwards. They were active until 1951, by which time the U.S. turns its attention to the Cold War. While unfortunately they didn't all look like Matt Damon and George Clooney, they were a pretty heroic bunch, and some later became museum directors and curators, and some actually already were. To expedite the matters, the Allied victors made the decision to return looted objects to authorities in the countries from which the objects had been taken, thereby transferring to the countries the responsibility for returning the works to the rightful owners. It wasn't easy. Europe was in ruins, millions of people had died or were dislocated, their heirs, let alone ownership documents, weren't easy to find. Some of the ownership disputes that have come up in recent years stem from this Allied decision. In 1995, in a wonderful book called The Lost Museum, Hector Feliciano revealed that of the approximately 60,000 looted works returned to France, about 2,000 were then still hanging in French museums. One of them was this lovely Monet, in 1904, Monet water lilies, that was discovered while it was on loan to the MFA in Boston in 1998 from the Caen Museum in Normandy, and was later returned to its pre-World War II owners. And of course, the recently ended long-running case that my colleague Larry Kaye litigated, namely the claim for the Adam and Eve. I'm showing you it on the cover of the IFAR journal more than 10 years ago. That's how long we were writing about it. Also stems from this Allied decision to return works to the countries from which they came, in this case, the Netherlands. It's a fundamental misconception, I think, to say that restitution issues are new or that works were not restituted after the war. No less an authority than Lynn Nicholas, whose book, The Rape of Europa, in my opinion, is still the best publication on this subject, estimated in an IFAR talk that about 85% or more of the looted works were returned within a few years of the war, and a lot of the remaining 15 or so percent went east to Russia, which had a very different attitude about restitution than the U.S. But after those initial returns and the final reparations made by the German government in the 1950s and 60s, the subject sort of fell off the radar. By the time I was in grad school, I don't remember it ever coming up, even though the former head of the department at Columbia, where I got my PhD, was himself a Nazi refugee. I must brag, however, because IFAR was writing about these issues as early as 1979 in our very first standalone newsletter, and I'm showing you now the very two Dürer paintings from the Ellisufan case that Larry Kaye worked on that was just referred to in the introduction. But in the 1990s, a confluence of circumstances brought the issue to the fore, including the books by Lynn Nicholas and Hector Feliciano and the declassification of war archives. But perhaps most significant was the 1998 Washington Conference on Holocaust-era Assets, spearheaded by Ambassador Stuart Eisenstadt. This conference spawned the non-binding Washington principles that were designed to help resolve issues related to Nazi confiscated art. 44 countries signed on to the principles. It was in these principles that the vague but very important phrase, just and fair solutions, which we'll be discussing tonight, was introduced. So the question became and remains how to right a historical wrong all these years later when works have changed hands many times, when documents have been lost, when the person or institution that owns the work is not only not the person, or almost always not the person responsible for looting it, but may have acquired it in good faith, not knowing anything of its tainted history. It's not always easy to answer that question, and restitution claims are very fact-specific. They also often depend on where the claimant or current owner lives. As you'll be hearing tonight, jurisdictions and countries differ on the way they treat ownership claims. Some foreign countries, but not the U.S., have also established panels to review the claims. In my personal opinion, restitution claims don't lend themselves easily to the U.S. adversarial winner-take-all legal system. Moreover, legal claims are expensive and take long and have often been decided on procedural and jurisdictional issues rather than on the merits, something that the recently enacted HERE Act was meant to address. I'm going to end now with just a few words about provenance research, although it could be the subject of an entire other talk, and I've given those. Provenance, which essentially means ownership history, has become a key to many restitution claims, actually a buzzword today, frankly. But it's not easy to do. It is essential to proving a claim or defending one, but isn't easy. It can be painstaking, extremely time-consuming process leading to one dead end after another. Moreover, the documentation uncovered, often incomplete, may be subject to interpretation, and the parties may disagree as to the meaning and significance, as was the case in this recent California trial concerning, I meant to show that when I mentioned the word provenance. That's my cartoon saying about provenance, and he doesn't give out his provenance to just anyone. But this is the painting I meant to show that was just at issue in a recently decided case in California, in Central District Court in Los Angeles. This is a Pissarro painting now in the Madrid Museum, and the parties argued over what the significance of all the labels on the back of the painting meant. Fortunately, there are many resources available to help. Recognizing the problem, IFAR actually held a workshop on provenance and due diligence way back in April 2000 and published the proceedings. We've also posted a comprehensive guide to provenance research, which we continually update. This is available free of charge on our website. In recent years, many other publications and significantly digital resources have also become available to facilitate the provenance research process and provide access to previously inaccessible archival documents. Very, very important. But provenance research still requires a combination of meticulous art historical research and dogged investigative skills. And you're not guaranteed results. I'm going to end here with this brief introduction to restitution issues and the complexities of provenance research, and turn you now over to my colleagues who are going to give you more specifics about other aspects of this topic. Thank you.
Thank you to the Historical Society. Thank you to Judge Rosenblatt and Judge Walker, Marilyn Marcus for organizing this event, this conference. As Judge Rosenblatt mentioned, I'm International Director of Restitution at Christie's, where for the last 15 years, I've led our global efforts to tackle the ongoing challenge presented by identifying artworks and objects spoliated during the Nazi era and their continued circulation on today's art market. I'm delighted to be here today to talk about the role Christie's and the art market play in resolving Nazi-era issues and claims. You'll hear from my fellow panelists about the role litigation can play in art claims, but I'd also like to highlight how in our work, practical steps and a soft law approach also have a place in finding fair and amicable resolutions. Given the extraordinary costs, risks, and delays that often come with litigation, we at Christie certainly believe it's best for the parties to a dispute involving a Nazi-era spoliation to take every opportunity to attempt to work out a voluntary compromise settlement. At Christie's, as I'll explain, we've developed a way of working with consignors and claimants based on internationally agreed guidelines like the Washington Principles of 1998, which I'll come back to and which Sharon described. It's a way of working which reflects our role as an intermediary between Christie's clients, buyers and sellers of artworks on the one hand, and families seeking to recover their former possessions and lost inheritance on the other. Because Christie's generally does not own the art that we handle, we can mediate the dispute between the actual parties. This is a fundamental difference between our work and that of some of my colleagues here on the panel, who are usually advocates for a single party involved in a dispute. But neither are we judge in these cases. We can only use our good offices with the express agreement of the parties to assist them in reaching an agreement and a resolution. It's self-evident that the art market, Christie's, other auction houses, dealers, museums, collectors need to be constantly vigilant and alert to restitution issues. There are considerable legal, commercial, and reputational risks if we misstep. But more than that, there's also a clear need for an ethical, moral, and sensitive approach to restitution, one that is embedded in our business practices and our role in the art market. We at Christie sell tens of thousands of artworks each year. The art market is a key net for catching looted art and gives us an almost unique position to contribute to the work of restitution. We're really on the front lines. We receive and must respond to dozens of claims each year, and in many cases, we're the ones to find possible signs of looting, causing us to initiate the resolution process. We look at thousands of items each year across nearly all categories of art, paintings, drawings, books, furniture, porcelain, books. To vet these lots, we have an experienced team with considerable knowledge and expertise and a body of information and documentation that has grown over the last 20 years and that continues to grow. We have also sensitized our specialists to alert the restitution team when a potential issue arises. In any given case, we might use up to a dozen online looted and stolen art databases or sources to help us. When we identify a potentially problematic item, we research it until we can draw a conclusion about its status, or we've made a reasonable assessment of the risk involved in selling it. The work is difficult and time-consuming, as Sharon described also a bit. A painting's appearance can change with lots of restoration. There may be a lack of tangible history for more financially modest works of art, such as works on paper, which historically had limited market value, but may be viewed as something very desirable these days. Or quite simply, there's a risk of confusion because a work's original description is vague and art is frequently created in multiple similar works. Because many of the databases we use are active and being updated, because numerous private archives remain still unavailable for research, and finally, because the research results can be subject to differing interpretations, a work thought to be clear of potential issues at one point in time can later be found to in fact be problematic when new information comes to light, or vice versa. The restitution cases we deal with on a day-to-day basis, and this can include cultural property disputes as well as claims of Nazi-looted art, are generally for artworks that are in private hands. Not often are they in museums. Many of the artworks we would all deem problematic are not clear-cut cases, so there are a great number of obstacles to overcome in convincing private collectors or private entities to deal forthrightly with an issue. This is often a difficult process, particularly if there's a sale in progress and the collector faces a potential financial hit. And many collectors who've bought artworks in good faith and possess them for some time believe that they have good title and don't recognize it as their personal responsibility to make amends for the past. In such cases, we have to try to find strategies to overcome this reluctance so that difficult cases don't all become protracted lawsuits. In this way, Christie's has resolved or turned over about 40 artworks in the last 5 to 6 years, and we've handled over 200 claims since 1998. Christie's approach is based on the spirit of what has become known as the Washington Principles. These principles, as Sharon described, were devised in 1998 when the international community, governments, lawyers, and practitioners from 44 countries convened in Washington for what would become a seminal conference on Holocaust-era assets. 20 years on, and the legacy of the conference has taken many routes. The creation of national bodies in several countries tasked with reviewing their national and institutional collections, litigation and legislation which has tested fundamental principles, which others on the panel will certainly discuss, and also the development of alternative dispute resolution or soft law approaches that I mentioned. The Washington Principles were reiterated in a slightly expanded form in the Terezin Declaration, which came out of the 2009 Prague Conference on Holocaust-era assets. We at Christie's also made public our own guidelines for dealing with Nazi-era issues and claims that same year. We remain the only auction house to have done so. The Washington Principles established the litmus test that resolutions to claims should be just and fair. A key consideration was to recognize a lighter, more relaxed standard of proof of ownership placed on second and even third generation family members, given the passage of time and the real difficulty of documentation after the turmoil, chaos, and the losses of the war and Holocaust. In many respects, the principles have been successful. They've provided an impetus for our own art restitution efforts and a lens through which we viewed claims handling and art restitution. But what we underestimated at the Washington Conference was the scale and the scope and the complexity of the challenge that lay ahead of us and still does. 20 years ago, when the Washington Principles were drawn up, we all thought in terms of Nazi confiscation. Today, our understanding of restitution claims mean we're not only just looking for artworks that were clearly confiscated or recorded by Nazi looting units like the IFAR, the Eisenstahlreichsleiter Rosenberg, which Sharon also mentioned, but we must also consider whether something may have been sold under duress because persecuted individuals became impoverished and needed money to pay flight taxes, for example, or to fund a new life beyond the Nazis' reach. To give you a flavor of our work at Christie's, I want to take a few minutes to share a couple of recent cases with you. We've worked successfully with a family in the United States who are unwitting holders of this problematic Egon Schiele. After the drawing was consigned to Christie's, our team identified the drawing as having once been in the collection of Dr. Heinrich Rieger, who was a major Schiele collector in pre-Anschluss Austria. Following the Nazis' arrival in Austria, Dr. Rieger was forced to sell off his collection to raise funds and had hoped to emigrate. Unfortunately, he was deported. We explained the drawing's ownership history to the consigner, a family who was sensitive and responsive to the problem and open to dialogue on how best to resolve the claim for its return to the Rieger heirs. We are fortunate to work on both sides with people willing to find a fair and amicable resolution. The drawing was successfully sold last week pursuant to a settlement agreement. A slightly more unusual route for us was the case of this Koninck. The painting was consigned to us from a private collection in Chile. When the painting arrived, it went through the standard cataloging and vetting, and during this process, we flagged it as having been one of the works confiscated during the occupation from the collection of Adolf Schloss in France. The Schloss collection was one of the largest and most important collections in pre-war France. After confiscation, the collection was stored at the Führerbau in Munich, where the painting was stolen a second time. With the fall of the regime imminent in April 1945, the Nazi guards deserted, and what followed was a night of looting by local residents. We don't know exactly what happened to the Koninck, but it turned up on the Munich art market in 1952, oddly enough in the hands of Walter Andreas Hofer, who had been one of the key agents for Hermann Goering during the war. Despite his wartime role, in the 1950s, he was free to sell this painting to the father of our Chilean consigner. Once our research uncovered this claim, we sought to discuss the matter with the Chilean consigner and begin the process of facilitating an amicable resolution of the claim. Instead, her family encouraged the Chilean prosecutors to bring charges against Christie's, and at that point, we reached out to the FBI Art Crime Unit to investigate the matter further. When the FBI's investigation confirmed our research, the U.S. Attorney's Office commenced a forfeiture action, which neither Chile nor our consignor contested. This led to the full restitution of the painting to the Schloss family at the beginning of April at a ceremony, you see on the slide, at the French consulate here in New York, attended by France's foreign minister and the Schloss family. At Christie's, we're proud of our commitment to Nazi-era restitution and our success in resolving issues when we can. I recall at the Washington conference there was much discussion about the likely duration of restitution as a concern and whether sunset clauses would be needed to draw it to an end. In fact, 20 years on, there's no sign at all that this issue and claims are abating. On the contrary, we're busier than ever as issues come up more frequently with the advent of increased accessible information as well as increased awareness of the restitution issue. As these cases continue, questions arise, such as what is the proper definition of a forced sale or sale under duress? How do we provide incentives for private collectors in possession of looted art to come forward and resolve their claims voluntarily, proactively? Again, another perennial topic, how do we centralize, manage, and make accessible information on Nazi-era losses? So to conclude, clearly our restitution is a multifaceted issue because every claim is unique. And rarely do we have complete documentation. And improving our current practices will require the input of many groups, families, advocates, provenance researchers, art dealers, auction houses, legislators, lawyers, acting together with a common interest in mind. For our part, Christie's continues to invest time and effort into upholding best practices, and we continue to develop these to meet the wider ongoing challenge. Thank you.
Before we hear from our lawyers, I just wanted to say one or two things about their presentations. We're going to hold them to pretty strict rules in terms of their initial presentations, but then we'll follow up with questions. I would just say one or two things here. Issues for those of you and the lawyers in the room that you may want to flag are issues of conflict of laws here, public policy and the role of public policy in developing law in this area, and the tension between cases, prior decisions of property rights and public policy in this area, and also questions of latches in bringing cases, also questions of the degree of amount of due diligence on the part of those seeking to determine the provenance, which matter. The presumptions and burdens of proof shift in these cases. But a great deal depends upon, at the bottom line, from having looked at some of these cases now, which country's laws will apply. If you're in New York, you're about the best place to be if you're trying to recover for looted art in the Nazi era. If you're in Switzerland, not so good. If you're in Spain, even less. So, but even in New York, you can have problems because issues of duress arise. And duress has been narrowly construed in New York, and it's been narrowly construed in other areas to be an actual force, as opposed to tremendous economic pressure that these people were under when they sold the art at far below market in order to make ends meet. Obviously, the people on the other side who were buying the art knew of their desperate situation and took advantage of it. I think of that as duress under those circumstances at that time, but the courts generally have not seemed to agree. So these are some of the issues that you'll be hearing about from our distinguished panel of lawyers. And we'll start now with Ray Dowd.
Thank you, Judge Walker. Thank you, Judge Rosenblatt, Marilyn Marcus, and Hal Kennedy of Wilkie Farr. I thought it was very important to focus on the history here. And I think there's some things that have been forgotten when the courts look at these questions. So here we go. Courts have overlooked Abraham Lincoln's Lieber Code and why that made the Holocaust different from scenarios like the ones that Bill Pearlstein will talk about involving antiquities. The cases are different factually, legally, and historically. The courts have really overlooked the London Declaration, which teaches us that a main victory and Allied objective in World War II was to undo duress sales. We won the war. It was and is our policy to undo these duress sales, and the courts have not faithfully applied that. Courts have also overlooked New York's Holzer versus Reichsbahn, and that's a story that I'll tell about a 1936 case in which New York courts rejected terrible acts of Nazism, and that was years before the United States entered World War II. And also, there's a case called Bernstein with a complicated name in which the courts were freed of the limitation of the act of sovereign doctrine from undoing the acts of Nazism, and were given a green light by the US government. And the result of the inattention to the history of this, I believe, has undermined the US victory in World War II. We won, we fought, we bled to undo what Hitler and his henchmen did. And I challenge the courts to remember that victory and the price. So here's a couple of cases that come out that seem to be in conflict. Cassirer versus Kingdom of Spain. Spain gets Nazi-looted art by the doctrine of acquisitive prescription. Okay, remember that one? It's a civil law doctrine that is akin to wrongful adverse possession of a chattel. And then we have the opposite result, where in Bachelor versus Vavra, the court applies New York law for an artwork in that jurisdiction. So I would submit that cases like these are problematic, they're in tension, and will ultimately need to be resolved somehow. But let's go back to first principles, the Lieber Code. Abraham Lincoln asked Francis Lieber, who was a professor at Columbia and a former Prussian military officer, to put together a code of war. And that code of war is called the Lieber Code, Executive Order 100, and it entered into our law and military law and was in place in the United States until the early 20th century. And what did it say? You can't seize property of the enemy. The spoils of war doctrine is basically gone, and it applies to artworks. And the U.S. signed the Hague Convention in 1907, which made that international law, and Germany was a signatory to the Hague Convention. So when we enter the 20th century, there is international law, and it says you can't steal works of art. So Hitler is different from those leaders who had looted previously in history. And how do we know the Nazis were the bad guys? They said so in their platform. They said that nationals can only be citizens of the citizens of the state. They went after Jews and to destroy the art and culture that they represented. And history's greatest murder until today has hidden history's greatest property crime. We can look at the military images, but that doesn't show us how things were taken from Jewish people. Most of it was in seemingly peaceable activities. So 9% of the Nazi total government budget was stolen from Jews. And here's what the London Declaration said. This was our declaration of what we were going to achieve in World War II, and is still today our foreign policy. And the punchline is that we committed to undo acts of Nazi spoliation that were seemingly voluntary transactions. Now, how do we know that we knew all about this Nazi looted art looting from the post-war period until today? Well, we can look at Milton Estro's article, Above the Fold, in November 1964, and Milton's here in the audience tonight, and he says, between 1945 and 1962, almost 4,000 stolen art objects were recovered in this country by the U.S. State Department with the assistance of other countries. So the public knew that Europe was trying to recover these artworks. It was on the front page of the New York Times. All these stories you hear about good faith purchasers who were so innocent, who got all these works that came out of war-torn Europe, it just simply doesn't make historical sense. Of course they knew. And of course we don't care in New York because we have no good faith purchaser defense. If there's a thief in the chain of title, no one takes good title. And this Hague Convention has long been part of our foreign policy, and here's the Holocaust Victims Redress Act of 1998, which cites that. Museum directors have testified to Congress that, oh no, they don't need to be regulated because they will undertake all this research, they will give it back. No, Congress, you don't need to pass laws to let property victims recover property because state law will let you recover. That's what they argued to Congress in 1998, and here in 2006 is a quotation from the head of the American Association of Museum Directors. Yet those same museums went to court and asserted jurisdiction and statute of limitations and cut off the rights of Jewish victims to reclaim their property. How do you prove the Holocaust? How do you prove this stuff happened? Well, Judge Walker made reference to the duress. Let's look at the James McDonald letter of resignation, December 27, 1935. He discusses how on April 1st, 1933, the Nazis put a boycott on Jews, an economic boycott so harsh that Jews could not buy food or medicine in parts of Germany. So this duress concept, that it was a generalized thing, is just simply not borne out by a close look at what happened in historical facts. Jewish property declarations, there's almost no scholarship of this. And this is, in 1938, April 27, 1938 law, Jews were required to register their property. If you had over more than 5,000 Reichsmarks, it was various categories. And the law, it said that all of this property will be available to Field Marshal Goering for implementation of the four-year plan. These declarations were filed every 4 months until the Jews had left the Reich. The Holzer versus Reichsbound case, that's a 1936 case in New York, where Marcel Holzer was an employee of the Deutsche Reichsbahn. They fire him because he's Jewish. They put him in a concentration camp. The Nazis put him in a concentration camp for 6 months. He gets back to New York and he sues. And the New York County judge lets him attach the office furniture of the Deutsche Reichsbahn. And the Nazi consul general comes in and said, there's sovereign immunity for that. And the judge said, well, sovereign immunity is a tribal issue. So this goes all the way up to Court of Appeals, and the Court of Appeals says, we're going to have a trial on this, on that issue. So 1936, 5 years before the United States enters World War II. And what are some of the things that we find in this case? And it's a very complicated case to read because there's a bunch of decisions that you have to cross-reference and go back and forth. And it's analogized to marriage and divorce cases, legitimacy of children, civil status. Are we New York going to recognize these Nazi laws that are so repugnant to our policy? And the punchline is the judge says, I do not view comedy as a sort of chloroform which drugs our senses during the operation admitted by the Reichsbahn, and goes on to talk about public policy. The other case that I wanted to draw to your attention is the Bernstein case. And the Second Circuit held that, well, this act that happened to a Jewish man, a contract, he was fired because he was Jewish or his property was taken. The Second Circuit said, well, it was the acts of a foreign sovereign. you, district court, may not review that act. The State Department wrote a letter, Jack Tate wrote a letter to the Southern District of New York and said the U.S. State Department wants to relieve the courts of this nation from all jurisdictional restraints in undoing the acts of the Nazis. And that Bernstein case, I submit, should really illuminate the work of jurists in understanding these cases. Thank you.
Good evening. I'm going to start by apologizing because my voice left me, but I'll do the best I can, and I think the microphones here are pretty good. And I'm going to show you pretty pictures, so you don't need to listen to me. But I start with a simple proposition that no one, even a good faith purchaser, can obtain good title to stolen property. That should be the predicate of Holocaust restitution law in the United States, because it turns out, and you'll hear it briefly, it didn't work out in such a simple way. Hitler and his cronies, as you just heard, loved old masters and other fine art, coveted it, stole it, had plans to take it before the invasions. They knew exactly what they wanted, and they took a lot of it. After the war, the Allies came and recovered a lot of it. The Monuments Men are famous now because of the movie and the book, and they used to go to, they sent most of the art they found to central collection points, but under the Allied policy of external restitution, it was too burdensome to return works to the victims, so they sent them back to the countries of origin. But as it turned out, the countries of origin, as the Holocaust, as people speaking at the Holocaust conference in 1998 that you heard about, noted, didn't do a very good job, and a lot of art did not get restituted. Notwithstanding the historical predicates that Ray mentioned, not really much happened till the mid-1990s, after 50 years of the anniversary of the war and the Holocaust. People started to remember it. Books were written, and many about the objects of art that were stolen during the war, and they created a lot of sensitivity. Plus, archives began to open up all over the world, so Provenance researchers could become expert in Holocaust research. And most importantly, as you heard before, the Stu Eisenstadt's 1998 conference on Holocaust-era assets adopted the Washington Principles on Nazi confiscated art, which basically said through the 11 principles that we should find the people who were victims, find their art, try to get it back to them. One of the first and most important cases which our firm was privileged to handle involved Leah Bondi-Giray, who was a dealer and collector in Austria. She had this particular picture in her possession in her private collection, not the dealership, which was Aryanized. And as she was fleeing to England with her husband, a Nazi agent said he wanted that painting, and she better give it to him at a very low price. Her husband knew the writing on the wall, and there was no choice. After the war, when the Allies came in, there was a drawing by Sheila in the Rieger collection. They got confused, they got mixed up. They ended up going back to Austria. They ended up in the Belvedere, the National Gallery. Later, a dentist becoming a collector came to London, Rudolf Leopold, and said, and Leah said, "Can you help me?" He said, "Sure." And he went back and he exchanged some of his own art for the Wally, and it ended up in his own private Leopold museum. He made a mistake many years later by lending the Wally to the Museum of Modern Art in New York, and District Attorney Morgenthau, at the request of the family, seized it, and there was a long proceeding, which was lost in the Court of Appeals, but the federal agents immediately seized it, and became an interpleader action that our firm handled. And eventually, after 10 years of litigation, the case was settled. The picture stayed at the Leopold, but the family got the then market value, which was some $19 million. There was a ceremony at the Jewish Museum here in New York. It was an important case, as these headlines show. Another case that started about the same time, which you're probably all familiar with because of the movie and the book, was Altman against Republic of Austria, which was one of the early cases, but very important. But after 10 years of litigation, the plaintiff ended up going to Austria and rather face an Austrian arbitration panel than go back to the lower courts after winning in the Supreme Court and face the hurdles that would have obviously been encountered, inevitably been encountered. And the case happily ended on a happy note. She got the painting back, but not in the U.S. courts. At the same time, the Houtsticker case started. Jacques was one of the most important dealers, if not the most important dealer in Holland, and had a wonderful collection. He had a lavish lifestyle in Amsterdam. He married the lady sitting next to him, Desi, who was an opera singer from Vienna. They gave lavish parties at the castle where they also had some of the art from his dealership. They lived in a wonderful house named Ostermeer. But when the invasion came, they fled, leaving their collection behind, and took the last boat out, which was a Kinder transport. Unfortunately, Jacques, there were no lights because of the war. Jacques went up on deck to have a smoke and fell through an open hatch cover and tragically died on the boat. But he had with him, when he died, his black book where he wrote down everything he ever bought, and it was all in there, his full inventory. After they fled, Goring came in knowing exactly what he wanted. This is Goring on the steps of the Houtsticker Gallery, and effected a forced sale of the artwork, set up an agent to take over the gallery, took 800 pieces to his estate in Karen Hall that were intended for the Fiera Museum. And Desi, after the war, the widow, because after Jacques died, went back with her 2-year-old son and tried to recover the art because of the repressive, unfair, bureaucratic post-war restitution process, which, as the Washington Conference noted, really wasn't that well intended to get things back to the Jews, could not recover the art. And it ended up staying in the National Galleries, the National Collection, until the late 90s, after the Washington Conference. Marai, the sole heir, Marai von Sacher, was the daughter-in-law. Her husband died in the mid-90s. Heard about the collection from a journalist, didn't know anything about it, went with her daughter and fought a good fight for years, almost 10 years. But finally, after the Washington Principles, the Dutch adopted better guidelines, and she was able to get the 200 Houtsticker pictures that had been stolen by Goring and taken to Germany back, and then went all over the world trying to get other pictures back. These are some of the wonderful pictures that she got back from museums, even in the United States, but by negotiation, except for these two masterworks that were probably the best works in the collection, which she fought for 12 years in California for. I can't go into the details of this complicated case, other than to say there's no doubt that these pictures were stolen by Goring, but because of the Dutch transferring them to one of the Stroganoffs based on a purported claim that we don't believe was valid, they were sold to Stroganoff, who sold them to the Norton Simon Museum, who defended the case aggressively for 12 years. And this past Monday, the Supreme Court of the United States denied cert in the case. It's a fascinating case, which could be the subject of a lecture, but very depressing, at least at the moment. Even though in the second appeal of 3 to the Ninth Circuit Court of Appeals, the court, relying on the Terrorism Declaration and the Washington Conference, said that this should be the policy of our land, and the court should try to get these unrestituted works back to the families, but the lower court judge did not agree. This is one good development, but not because of the courts and not because of the executive branch, but because of the work of many individuals, got Congress unanimously to pass the HERE Act, which gives a national statute of limitations, one that's very favorable to Holocaust victims. The Reith v. Nagy case is now pending, and it's interesting because it went for the plaintiff, but it also noted, just like the Van Sacher appeal, that this is the policy and very important. Then the Castro case, which you heard about, unfortunately went the wrong way, at least not in the plaintiff's favor, after 14 years. But there is a case pending by the heirs of Baron Herzog in Washington, which has gone up to the Supreme Court where they lost a technical battle, but is now back in the lower courts, and that one perhaps will have a different ending. You heard about duress. This is the case they were referring to. It's a case that we lost in the Southern District. We think that there was duress. We believe that the law of New York or Italy, whichever applies, does give a claim for duress to the plaintiffs, and we're on appeal to the Second Circuit right now. I end these talks often with Heinrich Himmler, and I do that because he said that back in the Nazi era that they should kill all the Jews because their grandchildren will try to get their paintings back. We think Mr. Himmler was correct, and usually I end my speech by saying that we're happy to be doing the work necessary to make sure that Himmler was right. But the fact of the matter is that the topsy-turvy swings of the pendulum in U.S. Holocaust-era restitution, which I gave you a taste for, of the ups and downs, has left me, who's been practicing in this field for 48 years, I know I don't look it, knowing only that there is absolutely no consistency in the courts. The U.S. courts seem to favor U.S. museums, while in Europe, the pendulum seems to be swinging the other way. Germany has been very, very active in restitution. And while the U.S. has made positive statements on the global scene, it does not seem to want to effectuate that in the U.S. I just think that it's not a good solution and perhaps an embarrassment. I think the Congress, as it did with the statute of limitations, has to step up and figure out a way to bring us a solution, a fair and just solution, so we get in step with the rest of the civilized world. Thank you very much.
My name is Bill Pearlstein. Let's switch from Nazi-looted art to antiquities, which present different issues. I don't have any pictures. It's beyond my technical capabilities. I'll try to keep it interesting. Most artifact-rich source nations nationalize every cultural object in their borders, in or out of the ground. These patrimony laws generally create constructive ownership and theft by statute and not by taking from an owner's physical possession. To me, the fundamental question with antiquities is whether U.S. federal and state courts should be in the business of enforcing foreign cultural patrimony laws. U.S. legal scholars first considered this issue at the 1970 UNESCO Convention in Paris. Contrary to popular belief, UNESCO does not contemplate universal national retention or automatic restitution. Instead, it focuses on national retention of a subset of objects important to national heritage while allowing private ownership and export trade. Even so, the U.S. delegation had fundamental reservations. They would not let the United States hand a blank check to foreign nations by automatically enforcing all-inclusive patrimony laws. In 1983, Congress implemented UNESCO by passing the Convention on Cultural Property Implementation Act. The act limits the forfeiture of stolen property to theft from possession, not by decree. U.S. import restrictions are finite and selective. They're limited to culturally significant objects and conditioned on findings of self-help, concerted international response, mitigation, international exchange. Repose is conferred on objects that have been exhibited by U.S. museums or long held by private collectors. Senator Moynihan, the primary sponsor, intended the Implementation Act to be our definitive national policy regarding the importation of archaeological and ethnological materials, balancing the competing interests of archaeologists, dealers, source nations, museums, state and justice departments, and customs. Tough balancing act. Yet, while Congress was deciding not to hand foreign nations a blank check, U.S. federal courts were handing it back. Under the late 70s McLean cases, criminal liability under the National Stolen Property Act can arise if a U.S. holder knows that an object was exported in violation of a foreign ownership law. McLean was opposed at the time by museum and dealer groups and criticized by Professor Paul Batdorf, head of the U.S. delegation to UNESCO and still the leading scholar in the field. He said, "The case erodes the distinction between stolen and illegally exported antiquities in a disturbing way. A blanket legislative declaration of state ownership of all antiquities, discovered and undiscovered, is an abstraction. Yet McLean gives this abstraction dramatic weight. Illegal export is elevated to theft. The exporting country, without affecting any changes at home, can invoke the criminal laws of the United States to help enforce its export rules by simply waving a magic wand and promulgating a metaphysical declaration of ownership." In 1985, Senator Moynihan proposed a bill that would have limited the Stolen Property Act to antiquities stolen from possession and not by decree. Professor Batdorf testified that the Implementation Act was designed to deal with the problem of archaeological looting and should control. General American criminal law should not be artificially manipulated to deal with the theft of unprovenanced artifacts. But state and justice opposed the bill on grounds of enforcement and diplomatic expediency, and the bill failed. In consequence, criminal liability can be triggered by imports permitted by the Implementation Act. The courts did not consider this tension until 2003, when the Second Circuit affirmed the conviction of Fred Schultz for conspiring to receive objects smuggled from Egypt. And at that time, Larry was representing or co-counsel to Egypt, and I represented a dealers association, or a bunch of groups, on the Second Circuit amicus brief. The District Court and the Court of Appeals considered the potential overlap between the two statutes and noted that bad acts can trigger overlapping remedies under civil and criminal law. But the District Court concluded, strangely I think, with all respect to Judge Rakoff, that the Implementation Act was not intended to deter theft, which is an interesting commentary in light of the legislative history. And both courts failed to recognize that McLean criminalizes trade that the Implementation Act was designed to promote. The Schultz courts could have concluded that as a matter of statutory construction, the Stolen Property Act should apply only to antiquities stolen from possession and not by decree, which the facts might have warranted. They could have gotten the bad guy. Instead, the Second Circuit affirmed on a broad theory of constructive state ownership. McLean ought to be conformed to the Implementation Act either by statute or judicial construction, or principles of comity should govern a federal or state court's decision whether to enforce a foreign ownership law. The test would be whether enforcement is consistent with U.S. policy as articulated in the Implementation Act, including findings of self-help, mitigation, and international exchange. That would be a more thoughtful approach than the rule of McLean, which tests only whether the defendant knew about a foreign ownership claim without testing the threshold question of whether, as a matter of public policy, a U.S. court should be in the business of enforcing the foreign law. The federal court's application of general criminal law to the complex issues presented by the international antiquities trade is at odds with congressional policy and, I think, the better thinking on the issue. I hope that the federal and state courts will eventually revisit the issue and bridge the gap. Thanks very much.
Well, not surprisingly, we have a few questions to ask here. First of all, if you are a client comes to you and is a member of a family of a victim, perhaps grandchild of a victim of the Nazi era, whose art has been stolen or taken in some way, but not just confiscated, but done through various transactions, and it's traveled through Switzerland. It's traveled perhaps to Holland, perhaps not. It's perhaps traveled and then ended up in the United States, where it sits in a museum after a gallery had it, sold it to a rich person, and then that person decided to take a whopping tax deduction because this art now is so valuable. And the Jew who originally owned the art was relieved of it for pennies on the dollar. what other questions that come to mind? What other questions as a practitioner that come to mind is when this client walks in and says, you know, I want to get my art back? And I wonder if you might be able to just kind of flag some of the issues and questions that would immediately occur to you that you would want to know from your client.
Want me to start?
Yeah, why don't you do that, Larry?
Well, that happens a lot. And when they come in, you try to get the history. As Ray talked about, history is a clear aspect of this, and Provenance Research, as Sharon talked about. You try to find out all the facts, find out what documentation there is about what the family had, when they had it, what title, how they prove title. Sometimes that can be done through title documents. Sometimes it's a photograph of a Picasso hanging over a couch in their grandparents' house. That's work too. And you get all the facts. You then have to find out who the family is, who the family originally was, who the heirs are. We've had cases where there were as many as 30, 40, 50 heirs. You've got to make sure that you find all the heirs, because if there's a claim, all those heirs may have a claim, and you may find yourself faced with a motion to dismiss for failure to join parties, or you may find that in the middle of the case, new claimants come in. You have to find out then what happened to the art. And there are different ways it could have been taken. As you say, it could have been confiscated, could have been stolen by the Nazis. But in terms of how our courts view these cases, forced sales by the Nazis, as happened in the Hautsticker case, are treated the same way as theft. And if there was a forced sale, you have to find out all of the elements of that. You have to find out then what transactions occurred after that, to the extent you can.
Let me just jump in on forced sale and the question of duress, because a forced sale where a person has been, a confiscatory tax has been leveled on this person because they have listed all of their assets pursuant to Nazi law, and then there is a special tax that's imposed on them that nobody else has to pay, that basically will deprive them of their wealth completely. And then they sell the art in that context. That's one scenario. Another scenario is you're on the run and you're trying to flee to get to Switzerland and maybe to get to another country, and you just simply have to bribe people. You have to pay flight taxes at airports, and various people are trying to extract money from you on the way, and therefore you need to raise money to do that, and you sell at more arm's length under those circumstances. Are those questions relevant, and how often do those come up?
So, Judge, you know, in that question, one historical thing we have to remember is that even after someone left the Reich, the Nazis would go after their families. And so even if they were in Switzerland, there might be a death threat against the families unless they liquidated property and returned it. So just glancing at it and say, well, they were in Switzerland, they were in safety, is very naive. And that's an assumption we see in a lot of the fact patterns.
And this is particularly true in Italy, correct, where the Nazis and Mussolini were working in tandem in the late 30s.
Yeah, and there's a history, for example, Sigmund Freud. He had left, and his family was stuck up, and he sent money back so that his family wouldn't be murdered. So if you look at those transactions, you say, oh, gee, Sigmund voluntarily sold his stuff, unless you have the correspondence that we see in the files. This was a systematic extortion of families, really beyond imagination.
The another question that I have here is, if you're in this kind of a scenario where you're dealing with art that has traveled via various transactions through various owners in different countries, to what extent does the choice of law question break out and become a choice of law for various aspects of the overall case? In other words, different choices of law depending upon what the issue is. Where was the duress? Where was the sale? That kind of thing.
The courts are not in agreement on that. I mean, we have argued in cases that wherever the theft was, the law of that country should govern the theft. When it gets sold, let's say in New York, the law of New York should govern that. But the courts are not necessarily agreeing with that. And after the Bacalar case, the courts are deferring to the courts are saying that if it was in New York for 30 or 40 years, doesn't matter where it was stolen, and what happened before, New York has the greater interest in it under the new conflicts analyses. We don't necessarily agree that that should be the case, but the courts are leaning in that direction. I recommend people, and it's on the web, to read the complaint in Leffman against Metropolitan Museum of Art, where you'll see what we believe was an extraordinary recitation of duress of a German family that had to leave Nazi Germany and ended up in fascist Italy and then fled to Switzerland. It's almost your scenario. We think it constituted duress. New York law was applied by the district court, who said they didn't think that it was duress because duress in New York has to be direct from the other party of the transaction. That's a dispute, and it's up on appeal in the Second Circuit.
Now, Monica has suggested that, and talked about the relevance of ADR and working through these cases to try and see if they could be settled. Is that an approach that you take at the outset, or do you try and do you feel that as a lawyer you must bring the case first and before you approach a museum?
Well, I'm a litigator, and people come to me really as a last resort. They've tried everything. And, you know, the economic realities of these cases means that I'm not really looking for another one. I am deeply grateful to my firm for supporting me for the 13 years I've been litigating this estate. So it's not like I don't think, you know, Larry, didn't say it. Larry's much more active in this and much more of a hero, I think, in this area than you know, I've been able to be involved with. But it's really, it takes a tremendous investment.
Well, can I say one thing?
Yes, please.
I agree, but we always still try to resolve these matters. And for example, in the Houtsticker case about the Chronics, we had 2 failed mediations. It took 3 or 4 years to do those mediations. So I have to say that we try, but I think generally the disparities of the plaintiff and the defendant in these cases are so extreme that it's very, very difficult to settle them. I know Monica has been very successful in resolving claims, both when she was at the Holocaust Processing Claims Office and at Christie's, and many claims we've settled too. But when the claims become larger, when they become, when you're dealing with large collections of very valuable pictures, it's very hard to bring the parties together in a settlement, and that's why you're having these long-term court cases.
Do you think it would make sense I mean, there has been talk here of the possibility of getting Congress to focus on this, and this day and age, it's hard to imagine them focusing on anything except beating up on each other. But apart from that, either get a committee of illustrious people who are steeped in this problem, and senior museum officials, senior representatives of other communities to come together and form a kind of a commission and reach a kind of a consensus that you might be able to, if you could reach a consensus, do more than just what the Washington Declaration did, which just took you so far, and then talked about a fair and just solution and dropped it, and see if there could be some kind of mechanism set up that you could take these cases out of the judicial system with all of its uncertainty.
That's been tried. And there are many people in this room who I see who have been at those endless meetings at the State Department over the last 10 or 15 years where we tried to get a commission. And the difficulty is the European commissions are generally based on national museums. It's the federal governments who, in the 5 countries who have set up the commissions, and that's why they work. Here you have a system of mainly private museums, and it's my perception, people may disagree with me, that it's been very difficult for the museums to agree to take it out of the courts, because as someone said earlier, they like being judge and jury, and if not, relying on technical defenses in the courts. That's just the way it is. My view is that there should be an alternate solution, but it should be more like the HERE Act, that finally, after 10 years of trying, first in New York State and then on a national level, and again, many people in this room worked on it over those years, Congress finally took it up and passed a legislation that solved the problem, or at least many of the problems, not all the problems. And I think that maybe Congress should take up the substantive issues as well, not just the limitations issue.
Okay.
And Judge, the Federal Bar Association, I'm active with them, and they've taken up the issue and support a commission on this topic. And that's one of the things that was in the Washington Conference Principles. There was some talk that within the DOJ, there's the Foreign Claims Tribunal, and that was an existing structure that might be used for this purpose.
Well, there was a time back at the time of the release of the hostages in Iran when a claims tribunal was set up at that time, and there were funds put into it, and people could come and make their claims. You'd have to find a source of funds, and people would have to donate to it, and then there would be a presumption of it's the equivalent of a very loosely conceived class settlement in which the class is varied and the facts are all varied. It would never fit under Rule 23. But somehow people could, if somehow there could be a common fund set up that could help at least get some recompense, where it's so difficult to prove particular cases. Some cases are easier to prove, but many aren't. And what I'm hearing from you is that the law is very uncertain in this area. It depends on the jurisdiction you're in. It depends even on the judge you have, and there's so many variables that you can't predict. It's very hard to predict what the outcome is going to be. I'd like to ask Bill Pearlstein a question, and that is, you've talked about how the courts have stepped in now, and basically with McLean, and then in the Fifth Circuit, and then in Schultz here in New York, and informed and enforced the National Stolen Property Act criminally to in effect support foreign jurisdictions, general ownership, statements of patrimony law, patrimony in which they claim ownership to property that they've never seen and that is not in their possession, and thereby, in effect, really dried up the trade, it seems to me, in much of antiquities situation.
Yeah, dried up the trade. I mean, it's interesting. What's really dried up the trade is the 1970 rule, and whereby the American Association of Museum Directors, or Association of American Museum Directors, took the position that they wouldn't access by loan or purchase or gift anything without clear provenance to 1970. Now, clear provenance is a subjective term. I mean, I've been in I had a litigation involving a Renoir consigned to Christie's. There were 6 different provenances. So provenance is itself an interesting concept. There's no title registry. And what's happened as a result of the 70 rule is that you have had hundreds of thousands of objects that, I don't want to say they're consigned to oblivion. There might be a private dealer market for them. The museums won't take them. The auction houses are increasingly cautious, as they should be, because Larry's going to jump down their throat if a stargazer, comes up for auction, just as, a plaintiff's lawyer jumped down Bellagio's throat, in my case, where a Renoir came up for auction. And when you represent a consignor and a claim hits the auction house, your consignor is helpless. Their object is tied up, their money is tied up. The consignment agreement, unless you come to me first and ask me to negotiate it, is going to tie you up and protect nobody but the auction house excuse me, Monica, sorry, it's sort of true, and you got to indemnify the auction house. So the antiquities market is tough. The best dealers are very careful. They survive. They have some of the best material at the TAFAF Armory shows. The people who are in business intend to stay in business, and they're very, very careful. Sometimes, if they're really smart, they get someone like me to look at them. The fairs are very careful about the material, but it can't insulate particular objects sometimes from claims which have various degrees of merit behind
Right.
them.
But part of the problem, I gather, is the fact that you have national patrimony laws that are just declared. Anything that's in the ground that was as of a certain date is owned by the state, and that is, they could have gone a different route, and they could have just said, you know, it's a violation of our export laws, our local export laws, to take these out of the country. They didn't. They claimed ownership.
Right.
And the ownership is now the ownership right of that country is being recognized in this country, and so theft can lie from a deprivation of ownership. And so I'm interested in what you might say about the fact that these patrimony laws really are what is drying up the market. I mean, is that really the problem, or are there other issues?
Well, I think it's the existence of patrimony laws creates the potential liability that has driven the museums to take refuge in the 1970 rule,
Right.
which has had this sort of derivative or spin-off effect or follow-on effect on the private market and the auction houses.
So that raises a question about antiquities in the sense that sort of if you step back and try and imagine, well, what is the best outcome that one could have if you are a sort of internationalist and you think that the value of this art should be experienced by the maximum number of people, not just the owner, not just somebody who's the Peruvian government or the Congolese government, but worldwide. Is there a solution to that can be worked out either through unilateral legal or policy development on this country, or would it have to be perhaps through a convention and some sort of broader
Well,
venue?
my one brilliant idea is actually 2 pages and about 8 paragraphs in that vast white paper, which somebody actually paid for, which is in the materials. And I think, you know, the big problem is there's no title registry, so you got a clear title. So I propose a 21st century solution where you publish, you expose, you vet, you give people, you know, countries, archaeologists, claimants, 5 years. I like 4 years because that's the UCC warranty of title. You give them 4 years to make a claim. You have some sort of rational claims process. And after the 4 years come and go, it's free and clear. But that's a market-oriented solution. It's met with virtual silence. Nobody's interested except me, not even my partner. And it'll go nowhere, and you'll continue to have the situation where Larry sues and, you know, people like me defend.
So let me ask my two friends on this side, do you have any comments based upon anything that has been said at this point that you'd like to, that anything occurred to you that you would like to comment on?
Well, interestingly, I sort of want to add to something Bill said. It's not even just the patrimony law recently that we tend to think of in a particular country, like 1939 for Italy, or something like that, but several countries are going back to even earlier laws, so that the subject is getting a little grayer in terms of when is legal to have acquired a work. I know this because we gather all these laws, as I said, and they're very hard to even obtain, almost impossible, which just makes it very frustrating for someone who really does want to follow the law. So I've noticed that pattern, for better or worse. I've noticed that pattern. Obviously, when you're dealing with antiquities, there's a separate issue, which is separate from law, which is that no one wants looting. Looting is an issue. And so there's a balance between the law, and I think they get merged because the sides get to be the collectors, museums on one side, and the countries and the archaeologists on the other side, effectively. But in fact, the countries and the archaeologists are slightly different, because one of the issues is you don't want destruction of archaeological sites, and you want them documented. This is important, I think. So there's that issue, and then there's the separate issue of what is the ownership and patrimony law of the country. They're connected, but that's the issue. Is there a good antiquities collector? There are many people who think that's an oxymoron. I don't happen to be one of them. I think that you can be a good antiquities collector and be ethical and follow the law. But some extremists might say that I'm wrong in even feeling that that's possible. So.
Good. I would like to see if
Can I make
yes,
one?
please, Larry.
Since my name has been used so much, and it looks like I frivolously run into court every other day, let me say that my view is that there has been a diminishment in the market, but it's a diminishment in the illicit market. That's all it is. I complained a few minutes ago about the inconsistency in Holocaust restitution. I'm delighted there's consistency in something, and it's that even before McLean, in cases before McLean, and all the way up through Schultz and after, there's been consistency that ownership laws of foreign countries are being honored, but it's not so simple. I've been litigating these cases for 48 years, and the fact of the matter is that just because there's a law doesn't mean you win. Under the McLean case, it has to be clear, and you have to make sure that it's clearly declares ownership of these antiquities in the state. Then you have to come and identify them. You've got to prove they were at a particular site. You have to know when it came out, and you have to know that there was a law in place that was clear at the time they came out. These are very difficult cases to litigate, but the bottom line was resolved by the Schultz case, where we worked closely with the U.S. government, and the issue was, is the CPIA dominant over the NSPA? And the answer was no. One deals with the export of property, one deals with the ownership of property. And it was settled then, and maybe it will change later, but for the moment it's settled. But it's still a hard job to prove that your ownership law works and that you have a right to recover that particular piece of property. And when something was taken under the ground, out from under the ground, it's not so easy to prove it was there. And in our first case, the Lydian Horde case, which those of you who follow the field know about, they were taken out of tombs in the dark of night, and we had to bring archaeologists in from the U.S. and from Turkey, and they meticulously showed that there was a compatibility between the objects taken out of Turkey and those that remained. So it's a pretty hard thing. It's not frivolous, and it's just it's something you have to prove.
We do have time for questions from the floor. If anybody has any, would like to ask any member of the panel here any questions. Yes, sir. State who you are. Step up to the microphone.
My name is Ron Goldbrenner. You mentioned
Is that on? I don't think so.
you mentioned before that the U.S. courts were a little bit more friendly toward the museums than the claimants. Can you tell us what the legal theories are that they mostly use to?
The question
Can you
is-
tell us what the legal theories are that they use to support denying restitution?
Well, very often, the cases are resolved on the basis of technical defenses. The statute of limitations, at least up until the time of the HERE Act, was the basic tool that possessors, whether they're museums or not, used to knock out these cases. The doctrine of laches in certain states was used. That's an equitable doctrine that most of you know, I guess. that even though the statute hasn't run, there's interminable delay to the prejudice of the defendant, and other technical defenses were very often asserted. But though the statute of limitations is one of the few issues we won on in the Good Sticker case, the fact is that in the end, it was decided on the active state doctrine. So different theories are used by different courts. And when I say, I'm not condemning any court in the United States, and I'm not criticizing them, except I do believe that there's a philosophy in the United States. We weren't there. We weren't the bad guys. We weren't the people that took it. And when it gets here, you know, it took a long trip, and it's not so fair to punish the people that are here. But on the other hand, we believe that it was stolen properly. Indeed, as the worst thefts in the history of mankind, and the special rule has to apply.
Yeah, I would say that museums suing Jews is a really disgraceful thing. And the history books now contain those cases, and they're good law in their jurisdictions. Detroit Institute of the Arts and Toledo Museum suing the same family in different jurisdictions on successive days and getting their claims, their counterclaims dismissed on a Rule 12b6 motion, which cut off all discovery to the Jewish families, was absolutely horrific. It doesn't make any sense. It doesn't make sense under the Federal Rules of Civil Procedure. It doesn't make sense under what's right and how our courts should be used, and it doesn't serve justice or the truth. And those museums that are hanging those paintings now should really be ashamed of themselves. And I went to Toledo, I went to their law school, and I gave my lecture. There were people shouting at me, there were people crying, they're like, who was the judge? And I've been very, very critical of the courts, unlike Larry.
Bill?
Yeah, can I, you guys are giving latches a bad rap. I've used it, or I've seen it used, I used it and I've seen it used in the antiquities context in several declaratory judgment actions against source nations, declaratory judgment actions to prove title. And, you know, it's a hard thing when a bona fide purchaser takes in the stream of commerce and a country like whoever, you know, whatever country, Lebanon, Syria, Turkey, Egypt, knew about a theft, sat on its hands, didn't report it to the art loss register, did nothing, allowed the work to circulate in the stream of commerce through successive owners who successively prejudiced themselves due to the inaction and, in essence, negligence of the source country. So you're starting to see an offensive use now of latches in the antiquities context.
Nobody up on this panel is from a museum. Some have represented museums, but I think that perhaps if there is somebody in the audience here who could speak for the museum, it might be a good idea, because one sees all sorts of incentives on the part of people with questionable art to give the art to the museum and take a whopping tax deduction, which may or may not be challenged by the IRS. And the museum sits there with a beautiful Picasso that Mr. Lefman had to part with for $12,000 in order to get out of danger. And there seems to be, in a very broad sense, a feeling of unjust enrichment on the part of the recipients of this art and the people who have it now. And I'm speaking in very broad brush strokes right now. I'm not talking in terms of any specific application of legal doctrine. But maybe there is a case for the museums. And if there is, maybe either somebody could speak up on behalf of a museum, or maybe a lawyer who once represented one at least could advance it. Yes.
My name is Sharon Cott, General Counsel of the Metropolitan Museum of Art.
Perfect. Well, this is we've got the right person, the General Counsel for the Metropolitan Museum of Art. Good.
I'm not going to speak in detail about the actor. That is pending in court. Larry has recommended you read the complaint. I ask that you also read our answer and follow the case. Sure,
You can take that
The
microphone off.
The Lefman case that Larry Kaye mentioned, I won't be able to speak about that in detail tonight, but I just recommend that if you read the complaint, and of course, on a motion to dismiss, everything needs to be assumed, all the facts in that. Leffman. Of course, on a motion to dismiss, you assume the facts as they are. So that is the current posture of the case.
Could you speak also to the question of what the museum does to determine provenance
Thank you.
before you accept art?
Yeah, I'd love to go back to the premise a little bit of the roles of museums in these cases, because there was a slide that showed the principles that the museum community has adopted. And the museum community pledged to Congress and continues to be actively committed to researching the provenance of the works in our collections. We put them online, we invest time and resources, and this is a search, a quest for knowledge that is foundational to the museum community. It existed before the Holocaust issues. It will be with us long after those issues. With the archives that opened, more resources were available for this research, and it's an ongoing effort. And as suggested on the panel, the search for the facts, the search for the truth is a commitment that we have all made. The principles that we adopted state that if a work was looted from a Holocaust victim, we are committed to returning it. I think what wasn't perhaps mentioned tonight is that there are multiple situations that have not gone to court where museums faced with information that they discovered on their own initiative and went to a claimant, or that a lawyer or a family member brought to them, has resulted in the return of works of art. And those cases are all listed on the AMD website. I believe they're up to 45 or 50 situations where the works have gone back. The ones that end up in court, I can't speak for each museum, each of the facts are individual or different. I believe the common thread is that in those cases, the museums do not believe the work was looted from a Holocaust victim, that there are disputes as to the facts. Once in a court, some of the decisions have been procedural rather than substantive. So if that's helpful, that's how
Very
we
helpful.
approach them. Thank you.
Does anybody else have any other questions or thoughts?
Judge, I represented the Pergamon Museum in recovering an amulet, and we took it up to the New York Court of Appeals and won. And the interesting thing there was the museum was accused of not warning the world that it had lost this object. But it was a unique object. It was in the museum's collection, and it was the government, and it had documented that work in its collection. So sometimes even when there is inaction, the world can still be on notice.
Good, thank you. We are now, yes, did somebody?
I just wondered with the advent of the internet since '98 and the opening of the archives and the declassification of a lot of this material from the Nazi era, including work of the government, you know, do you anticipate that there is going to be additional cases as people, you know, in the 50s or 60s, they may not have been aware of auction houses or exchanges or sales, but, you know, you can set up a Google search right now and, you know, every time a particular work pops up, you'll be aware of it. Do you anticipate that that will further additional claims?
Well, it is already, and there was a meeting before the Holocaust conference in '98 of art experts. Monica was there, I was there, other people in this room were there. And somebody said, I think it was the Art Laws Register, well, this should take about 3 or 4 years, and then we can wrap it up. And obviously that hasn't happened, and I think it's going to continue too as more information becomes available, and it is every day.
Right, if I could just add, that's one of the biggest challenges for Christie's and for us. New information comes out all the time, and more information is becoming accessible. regularly. None of this information has been centralized yet to a huge degree. We're getting there, but new information surfaces all the time. And one of the biggest challenges is we can only do the best due diligence we can at one point in time when a work is consigned to us. But new information might come out, a year from now, or a book is published about a particular collector that might have suffered during World War II, and then all of a sudden the family sees that they have a potential claim. So new information is coming. It's a moving target. I mean, the landscape keeps shifting, and there's more and more information coming out.
Yes, we'll take this. I think it'll be our last question.
I've been working a little bit on the Jewish Cultural Reconstruction, which was an organization that gained legal standing to become the trustee mainly of books, but also of Judaica and other cultural objects when there were no living, that is to say, surviving parties to claim looted objects. And I'm wondering, as we have sort of the timeline of archives becoming more and more accessible, but the survivors and heirs becoming less able to exact a claim, whether there is the prospect of any similar organization that is similar to the Jewish Cultural Reconstruction that could become the trustee, the legal trustee or legal heir of items on behalf of the Jewish community, if there is no surviving heir to exert a claim, if a claim can be proven.
I'm not sure I understand completely the question, because the issue has come up many times, what's going to happen with the orphaned objects, where we just don't know, the heirless objects, where we don't know where the families are. There may not be any heirs. Many years ago, Christie's actually was involved in the Mauerbach sale, where money was given to the Viennese Jewish community from the proceeds of the sale. But then later, there was some criticism about that because it was before a lot of the research was done, and some of the works actually could be traced to families later on. Now there's some suggestion that the works go to Israel, but I think there's a lot of dispute. I don't know that there's any agreement as to what should happen to these heirless objects. Maybe Monica has some more to add on that.
I mean, I just think that the discussion is sort of premature. I mean, I think that we still, I think there's still a lot of work to be done, and a lot of research and materials that are still going to be coming out. And I think it's just too early to sort of declare what might be heirless or not. That was the issue with Mauerbach. I mean, Christie's did a sale of property that was found in salt mine. It was in '96. And, it turned out again that there wasn't a lot of accessible information. And later on, you could actually trace some of the works that were sold to families.
Well,
There's if I may.
Quickly, yeah.
Dr. Wesley Fisher of the Jewish Claims Conference has been really active in holding countries' feet to the fire in terms of doing the right thing. The JUST Act, which was signed by President Trump in 2017, requires the U.S. State Department to report on the activities of various countries on this issue. And I think the report should come out this September. So that's a diplomatic effort that is ongoing, and Ambassador Eisenstadt is very active with that.
Well, I would like to thank our panel for an excellent presentation. I would also like to thank, like to recognize Marilyn Marcus and Al Rosenblatt from the New York Historical Society. Please stand. Please stand up. Without their hard work and organization, we wouldn't have been able to have this evening. So thank you very much.